Good morning, welcome to this session. My name is Jagvinder Kang, I'm a director of the law firm InTechnology Law Alliance, and I'll be talking about some of the key issues to consider when engaging with a cloud service provider. We're providing an overview of these four issues, so internal business decisions, due diligence, and how the cloud models affect contractual negotiations. And then lastly, why adopting a bulletproof approach to contracting is completely the wrong way to go about cloud computing. So let's kick off with internal business decisions. And broadly, in organizations, they will fall within three categories: commercial, technical, and legal. Taking those in order and starting with the commercial decisions. One of the key things for any organization looking to deploy the cloud or go into the cloud is checking, is the cloud actually suitable for our business requirements? There's a lot of hype about the cloud, as everyone knows, and one needs to make sure that one goes into it with one's eyes fully open, aware of all the issues associated with it. You need to be aware of what are the benefits of the cloud and do they align with your actual requirements. So is there a need to increase or decrease arrangements based on volume transactions, and you require that flexibility? Is there a requirement to plug a resource gap within your organization? You don't have enough in-house expertise or resource to deal with something, and the cloud can plug that. Is it that your business continuity and disaster recovery measures that you need to put in place are better achieved by putting these arrangements in the cloud and using that type of infrastructure? As long as you can answer yes to these types of questions, then that's fine. You've undertaken some of the commercial requirements and undertaken that sense check rather than blindly going into the cloud. You need to also have a look at whether the cost model stacks up for cloud arrangements. So are you going into the cloud to avoid some of the high-end upfront CapEx costs that you would have in your own organization associated with buying an infrastructure or software, etc.? Is it to avoid technology refresh? You need to factor all those types of issues as well into your commercial decision as to whether the cloud is the right thing for yourselves. And you also need to understand commercial risk. So which kind of risks would your organization be facing by going into the cloud, and can they be overcome? I know the audience here, most of the people here are from the IT teams or CIOs, and one of the issues that we often see as lawyers when we are advising supplier side is that the customer is often frustrated because it requires the expertise of their in-house IT team to put this input into the contract. What are you actually looking for from a technical perspective? However, the customer sometimes forgets that the IT team also have day jobs. And that is a risk, because you need to make sure that within an organization there is buy-in, that if the cloud deployment is mission critical, high value or complex, that there is going to be resource freed up internally within your organization to allow this kind of input into the contractual arrangements associated with cloud deployment. Then there's technical decisions. So these will be very much the things which are going to be in your arena. Which cloud model is going to be deployed? Is it going to be private cloud? Is it going to be public cloud, hybrid cloud, community cloud? Which type of model is best for your organization? And which safeguards are going to be provided for? We've heard from some of the speakers about security, business continuity and disaster recovery. Which things are actually important to your organization? Are there particular standards that you need to comply with? And will your cloud service provider be able to offer those types of standards? We've had that in some of the questioning of the last speaker. You also need to consider about the cloud interaction with the internal environment. What are the touch points with your internal environment, even if you go to a cloud model? Which kind of factors do they give rise to from a technical perspective? And data migration, both at the start and the end of the cloud arrangement. If you are going to be deploying data, is that going to reside wholly in the cloud? Is it going to be sent on a transactional basis? How are you going to get the data back? What kind of format does it need to be in? Who's going to do the legwork of that? Are you going to do it? Is your provider going to do it? Are you going to need a third party to do that? Then we've got legal decisions, and I'm not going to say too much about this because we've got a specific session on legal later on today. But there are going to be the usual things that have been touched on already, data protection issues. There's going to be regulatory compliance. If you're operating in a regulated field, you will have your internal compliance officer. And you will need to therefore check that what you are proposing to do ties in with those requirements that your organisation is subject to. And you'll also need to be thinking about contractual comfort. What kind of assurances is the cloud service provider going to provide? And Alvin's again touched on some of the things that net documents do with regard to that, and that's something that you need to make sure that you have clarity on. So all of these things lead to due diligence. That's the way you're going to be able to make some of these decisions. And they are going to map on to those things, commercial, technical, and legal again. So from a commercial due diligence perspective, in addition to what we've already discussed, there are other factors. Your organisation needs to think about the financial standing of the supplier. You can go through all the technical due diligence, you can go through all the commercial due diligence and think this is a great fit for our organisation. You can think, well, the contract will cover everything else, but a great contract's not going to be any good if the supplier goes bust. You need to think of it, give serious thought to obtaining client references, but maybe taking a step forward. Having a look at whether there is the opportunity to talk to some of the clients of the service provider, whether it's possible to undertake site visits with them, to talk to their teams, to find out how was the arrangement right from the start, right from the transition, the ongoing service, what kind of issues has that organisation faced, and has the service provider been responsive? And you'll only get that real-world knowledge by talking to other clients, similar size as yourselves, similar industries. And if that's available, that will give you a good gut check of whether this seems to be the right provider for what you are looking to do. Because again, the contract can protect you, but you don't want to be, at the end of the day, relying upon going to court and suing them for remedies. You'd much rather have a scenario where you've got that upfront confidence that this service provider will look after you because they're looking after their other customers and they are responsive. You need to also check the commercial position. So we said at the beginning, does the cost model stack up? What are the arrangements within your proposal from the service provider with regard to pricing? How long is that pricing fixed for? Does the pricing go up or down? Is there indexation which automatically applies? So there's those kind of thoughts which need to be gone through. And importantly, you need a plan B. You need to plan as an IT team within an organisation, as a commercial team within an organisation, what happens if things go wrong? Things could go wrong right at the start, the transition phase. They could go wrong while you're actually having the service delivered. They could go wrong right at the end in terms of exit or in terms of the supplier actually going insolvent. Technical due diligence. Consider on-site visits with the service provider and see whether that can provide you with some of the comfort when you can have a look at some of the security and safeguards that they have in place. On high-value transactions that we advise on, often multi-million-pound cloud computing contracts, what will usually happen is there will be a walkthrough of business continuity and disaster recovery plans and checking the alignment between external plans and internal plans. How do they interact, and do any changes need to be made in view of the type of arrangement which is now being sought to go into? Technical understanding of data migration, as I mentioned previously. What kind of format does this data need to be in, and who's going to do the legwork, and is that something that your organisation is on top of? And checking that the technical solution meets the requirements. This seems like a very obvious point, and when there is ever a dispute with IT contracts, it's because of this failing. What typically happens is the commercial team and the technical team are quite comfortable that the service provider is going to provide what they feel they need. Unfortunately, it isn't reflected in the contract. And that's usually going back to the fact that there are resource constraints within a customer due to day jobs, due to resource allocations, due to the rush to get the contract done, that this can sometimes be a failing. So it is important to ensure that the IT team is actually involved early on with the legal stream, with the commercial stream, with regard to cloud arrangements. It doesn't sit separately and tick the box, yes, technically it will do it. They need to be an integral part of the commercial discussions and the legal discussions. I write for Computing Magazine, and I do a web blog for them on a regular basis, and this is one of the topics that I've just recently written on, because it is overlooked. Having advised on technology contracts for over a decade, it's still the same issue, that the IT team often seem to be divorced from the legal arrangements or come in quite late. They need to be involved right at the outset. On complex arrangements, you also need to consider whether it's worth conducting a pilot, a small-scale deployment, to see whether you are receiving the type of interaction from the cloud arrangement which is reliant on third-party infrastructure to actually achieve what you're looking to obtain. And that's something worth discussing with the service provider to understand what the consequences and practicalities of doing that would be. So with legal due diligence, as I mentioned, it is very, very important that the IT team are involved with this, with the legal team up front, that they are feeding through to the legal team which are the important bits that we from a technical aspect need to understand. Is the cloud service provider going to sign up to these standards? We're advising on contracts at the moment where some companies don't have particular standards which an organisation requires, and the organisation is still comfortable as long as there is a roadmap to achieve that compliance within a certain time frame. Now that's only going to go into the contract if the IT team have flagged that it is an important technical requirement and they do require it by a certain date. If you don't have it there, then you are relying upon the goodwill of those discussions up front to ensure that that actually happens afterwards. But it's also important to have a think about, again, on high-value, mission-critical arrangements, whether it is actually worth having a tender process flagging some of the key principles. Again, this isn't something you should leave to the lawyers, as they'll throw the kitchen sink in and get a very big document. What you should be thinking about are, what are the key important aspects for your organisation? If you go with a particular service provider, what is very important to yourselves? Is it audit? Is it security? Is it having termination for convenience rights? Is it benchmarking? Flag all those early up so that can be incorporated in the tender exercise at the beginning. Also consider what kind of contractual basis that the supplier is looking to contract on the basis of. Since I've mentioned that the IT team should be integral to the contractual arrangements, you should consider requesting a copy of the contract that the service provider is going to provide. Not because you're lawyers and you're going to be looking at it from a legal perspective, but there's a lot of things in there which will impact you from a technical perspective, and if they're not there, that you may want to raise upfront to say, well, we can't see this in the schedules, we can't see this in their standard contract, we can't see these kind of, the service levels are no good to what we're looking to achieve, we need higher service levels, or we need compensation which goes above what they are proposing in their standard. The other thing that often occurs with organisations, there's sometimes a mentality of, right, we are a large organisation, this is a high value contract, it's mission critical, we're not going to use a supplier's terms and conditions. We're going to have our own terms and conditions drafted by our lawyers. Well, sometimes there's good reasons to do that, but sometimes that can be just prolonging the process. Because if you've got a supplier, and a competent supplier, they will provide you with terms and conditions which are aligned to the way that they work. If you come up with your own terms and conditions, you're trying to then impose that on their model, which you're going to have resistance with, and you're going to have to negotiate everything. Sometimes it is better to start off with the supplier's terms and conditions. There'll be things in there that you don't like. There's nothing stopping you negotiating those aspects. We don't like the liability provisions. We don't like the termination provisions. We want to negotiate them. But at least the framework is mapped to what the supplier is looking to do on a daily basis. Next aspect that I want to touch on is the cloud model's influence on negotiations. Different cloud models will give rise to different issues, both from a business, technical, and contractual perspective. So on the public side, less flexible terms and conditions because it's meant to be a vanilla offering. It's meant to be a relatively low-cost offering. So you're going to have less ability to actually negotiate those terms and conditions. there's going to be less